All right. Good afternoon, everybody. Welcome to BioStrategy Partners Practical Knowledge Series. I'm very excited for this panel today. Have a very well-rounded experts with us today, and very excited to share this with you all. My name is Brian Chow, the Program Director of BioStrategy Partners. We're a nonprofit consortium that strives to really advance early stage technologies by providing administrative, educational, and investment support. I'm happy to discuss further if you have any more questions about our other programs, such as the Germinator or the Keystone Innovation Zone. My email is right there. Just jot it down and then send me an email if you have any questions. All right. Before we go into the panel, I just want to give a shout out to our sponsors. I'd like to thank NVM Associates, Center for Diagnostic Discovery, Meniscus Limited, as well as Saul Ewing for sponsoring our Practical Knowledge series today. It's very much appreciated so that we can help educate our scientists on commercialization. All right, a couple of housekeeping items before we start. Please mute your mic at all times. If you have any questions, put them in the chat, and I'll just ask them if as they come up. And then we also have a dedicated Q&A question at the end. If the conversation's going at the time, I'll probably just keep the questions to the end.
Never know how to get out of this.
Okay, there we go. All right, and with that said, I will just going to briefly introduce our moderator today. Is Jacob Waier from Penn State University. He's the technology licensing officer there. And I'll just let him give a little bit introduction for himself and take it away, Jacob.
Thanks, Brian. Hi, all. As Brian indicated, my name's Jacob, Jake, if you will, and I work as a technology licensing officer at Penn State. My background is my education is in physics and law. So I went to the University of New Hampshire and specialized in intellectual property. Prior to this position, I worked in patent prosecution at a law firm. So a little bit of experience there, I think around 18 months or so. And while I was there, I primarily worked with AI in the medical industry, primarily like predictive AI for medical diagnostics and image processing. And then as I transitioned to the university, I kind of got shoved into software again based on my background, which I have no complaints about. It's something I enjoy working with, and AI as a hot subject is always fun to learn more about. And here, just continuing to work with software and AI. I think I will hand it over to our first panelist, Sean.
Thanks, Jacob. Hi, everyone. Sean Ritchie. I'm an IP attorney with Saul Ewing in our Philadelphia office. I have a background in bioengineering, and my work has focused mostly on life sciences and engineering. Lately, and for a while now, I've worked quite a bit with technologies involving AI and various different applications, particularly machine learning models in the medical field, such as diagnostics, therapeutics, and predictive applications along those lines. And I will pass it over to Dave.
Very nice to meet everyone. My name is Dave Latshaw. I'm the CEO and co-founder of a company called BioPhy. We're focused on using artificial intelligence for drug development. So, I've been doing this for about 15 years in my career, 4.5 with BioPhy, 6 years before that doing artificial intelligence for Johnson & Johnson in discovery all the way up through commercial. And prior to that, I did my PhD studying computational biophysics and molecular biology. So this has been a large part of my career, and I've always enjoyed keeping up to date on the latest in the space. So happy to share my thoughts around artificial intelligence and the trends in IP protection.
Hi, everyone. My name's Alex McGee. I'm a patent attorney at Howard & Howard. I focus on biomedical and automotive technology in the mechanical, electrical, and computer science spaces. The AI portion of my practice is largely focused on policy formulation, compliance, regulatory compliance, and software development. Last year or so, I have focused a lot on building tools related to patent protection and prosecution. using generative AI. Really happy to be here.
All right, thanks to all of our panelists for their introduction. So I'm gonna just try and lay out a rough structure of how we plan to discuss things. So in the first half, we'll kind of talk about how each of us see AI being used, how our expertise relates to that, and then after that, we'll move towards some tips and tricks, some how we maybe see things moving, and maybe some advice on how to mitigate problems that could come up. So to start with, I'll talk about how I see AI being used at the university. We see it all over the place. Software has just infiltrated every single aspect of innovation. And along with that, so has AI. I'm sure we're all aware of how powerful it can be. Specifically, predictive models in bio, I've seen that plenty of times, and I know the College of Medicine and Innovation is constantly getting disclosures with that. I have colleagues constantly asking questions. And then other areas I've seen it in is business in general, agriculture, all over the place, but we'll stick to the bio side of things for this meeting. And then as large language models have been getting more and more prevalent, I think it's ChatGPT 4 has really been in the last year or so that's really started to gain traction. So we've been starting to see more disclosures with the generative AI, along with the predictive AI. And then with all those, some of the risks that, or I guess maybe not risks, but problems that could potentially happen at the university between, well, I guess I'll start with the specific to LLMs would be what the professors are signing up for using with the LLMs. So for example, most professors, as far as I'm aware, aren't really training their own large language models to be used for their own research. Generally, they are accessing ChatGPT, for example, or others. I'm really only familiar with ChatGPT. That's the primary one I've seen, but I know there's others being used. And on that front, so one of the things that professors should be aware of and others should be aware of is reading the user agreement that professors are signing when they are purchasing these services to be used. Some of them may be more or less permissive on what you actually own when using their technology. And then I know one of the business models of ChatGPT is to kind of give you your own version of the large language model that you can kind of tune to your own needs. And so based on their user agreement, you don't really own the IP in that based on my reading of it, but you can own the inputs and outputs. But there's things that go along with that, and then just expand that across all of the large language models that you might encounter. That's just something to be aware of. And then as far as intellectual property protection, I think we're all well aware of the patent system, but as far as some 101 considerations go, so would be patent eligibility. On that front, there's a quote, anything man-made under the sun can be patented, but software, which AI is, kind of an exception to that, but there are ways to overcome that. And we'll touch more on this later. I think Sean will be speaking more about this later. There's ways to overcome that for integrating it into a practical application. And so that would be more so instead of your professor saying, oh, we have a model that can do X, you would want their model to be doing X to solve problem Y, if that makes sense. So, and Sean will touch more on that later. But since I've explained kind of how I see it from an academic side, I think it's a good transition into things Alex has seen from corporate policy versus academic policy, and how we can formulate those policies to help address these needs and issues that he's seen.
Yeah, absolutely. I mean, I'll start by saying I think all organizations should have some form of AI policy, whether it's an extension of an existing, acceptable use technology policy, or if it's something separate and very specific to what it's being used for, or even multiple ones for different applications or projects. Reason for that is the potential risks extend way beyond issues with just protecting IP, data privacy, confidentiality generally, plagiarism, copyright infringement, regulatory concerns, in certain spaces, HIPAA violations or securities issues. You got to take this seriously, and I think it's very important to calculate those risks for your organization. The two most common scenarios I run across are either organization has banned AI tools outright, which I'm not a fan of, or there's a complete lack of a policy. Both of those scenarios to me indicate a lack of understanding of how the tech is actually used or currently being used. And that lack of understanding creates risk. If you don't appreciate what's being done with it, how can you plan for the contingencies? There's not a one-size-fits-all approach to implementing a policy for your organization. The risks are incredibly subjective and need to be clearly understood so you can figure out what's important and implement and enforce a meaningful policy that balances that risk with efficiencies that you can actually leverage using the technology. You do need to revisit and update the policy if you have one already frequently. New tools are coming out all the time, and existing tools get new features that fundamentally change some of the initial considerations you might have put into your first policy. And as the technology becomes more and more ubiquitous, the risks are going to change, and hopefully for the better, but they're not going to go away for a while.
Okay, so another issue that I think all of us have on our minds is the problem of inventorship when it comes to AI. So as I said earlier, anything man-made under the sun can be patentable, but so how do we attribute things that were invented by AI that's not really a man? So I think we'll first be turning to Sean on this.
Yeah. So Alex is going to dig into whether AI can be listed as an inventor a little more in detail. Before he does that, I'm just going to touch on whether AI should be listed as an inventor. In other words, determining if AI is an inventor for given technology. So just as a baseline, the threshold question for inventorship is who conceived of the invention? And when we're looking at an individual or AI, did they contribute to conception of the invention? And in practice, that can be difficult to sort out. One of the things that we don't have to deal with in terms of AI that you often see in the lab is kind of the emotions of how much work did someone put in. Because when you're talking about conception of the invention, one thing that is not included is working under the direction of someone else. So that would be, running a bunch of experiments under someone's guidance to validate data. It can be a lot of time, a lot of effort. You would certainly be listed as a contributor on a paper, but you wouldn't be considered an inventor in that case, or in most cases under that situation. So when we talk about conception, it's, and I'm going to read this here, a quote from a case, it's the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention. So it's kind of a lot to wrap your head around. But one thing to consider in view of that is that it does not require a reduction to practice. So if you can conceive of the invention in a way that you could essentially tell someone else how to make and use it or enable it, you've likely reached that inventorship threshold, and it doesn't have to be performed. So when you're thinking about AI and implementing it in that context, you can see how this can get muddy as to whether or not AI is an inventor based upon how much was input by an individual and how much was produced by AI. So that kind of where does that leave us now? There's a lot of uncertainty with respect to how much AI assistance is too much for patentability. We do know that involvement of AI can be and is eligible for patent protection. But again, it's really how much human involvement was there, how much AI assistance was there, and looking at that balance and trying to determine from there whether AI is an inventor or not. Last point I want to make on that front is that inventorship is always determined by the claims. So when you're drafting a patent application, there may be a lot of information you include that comes from the AI, maybe AI assistance. When you get to the claims and you're defining the scope of protection, that's where you want to consider this. What did the individual or human person do? What did AI do? And how much of that is going to be necessary to enable the claims. And with that being said, I will pass it back to Jacob.
All right, I think Alex is going to discuss Dr. Thaler and his experiments on patents with AI.
Yes, Dr. Stephen Thaler. So Dr. Thaler filed both patent applications and copyright registrations in a whole bunch of countries around the world. And relative to patents, he filed listing an AI tool that he developed called DAVIS, a device for autonomous bootstrapping of unified sentience or science, depending who you talk to. DAVIS was listed as the only inventor on these applications. And Dr. Thaler has maintained that he did not contribute in any way to the inventions other than building the tool. He certainly didn't contribute to the conception of what was filed on. In the US, his applications were deemed incomplete procedurally for failing to list a human inventor. And Dr. Thaler fought this pretty aggressively and frankly, as far as he could, all the way up, he attempted to petition the Supreme Court, and it looks like has denied review. The current lay of the land of the US and most of the rest of the world, except for South Africa, is, as demonstrated by these test cases, is that an inventor must be a natural person, as Sean has said. It's got to be a human. These cases that Dr. Thaler had, these applications that he had filed, give us some important insight, but they really don't answer the most complex or the more complex questions surrounding mixed inventorship, I'll call it, where you have human and AI contribution. The general conclusion people have right now is AI cannot be an inventor, but we don't know how much human involvement there actually needs to be, just that there needs to be some. Dr. Thaler's attempts were pretty academic. He specifically sectioned himself off. He didn't try to say he was a co-inventor or that he had a very specific scope of inventorship. It was an academic inquiry. Can the AI be the inventor? And really the answer we have is not the only inventor. My biggest takeaway from what we've learned so far is that we should actively avoid characterizing AI as any form of contributor or inventor. It needs to be thought of and treated like a tool, not an entity. Now, nobody's got a crystal ball, but when we revisit the issue again, when we have so-called true generalized artificial intelligence, this is going to upend everything. But as of right now, you got to have a human involved, and you need to draw very clear lines around what your inventors did and did not do. I think the risks involved with this are obviously invalidity. If you have a patent that's being challenged in court and turns out you didn't actually have a human involved and somebody's able to demonstrate that in some way, you got to have a human involved. It's not valid. So got to take great care to draw those lines.
All right, thank you, Alex. So we've talked a bit about the legal considerations of things. Us lawyers always being cautious. So we'll move on to Dave, who's going to speak a little bit about his industry experience, and namely the difference he sees between how startups are using AI versus how maybe big pharma is, or not necessarily pharma, but the bigger companies are using AI.
Yeah, happy to. So I think the best way to think about this is to probably break it into two pieces. One being the language model piece of the puzzle, and then the other very, very high focus area for biotech and pharmaceutical companies is using artificial intelligence for the discovery and development of new molecules. So on the language model side of things, which by and large, the major use case is, a co-pilot sort of use case or something that acts as an accelerant for the day-to-day work of the employees of the company. The major trend that has emerged is effectively having, a private version of ChatGPT, as an enterprise version that is, ideally based on the agreements with an OpenAI or Anthropic or whoever it happens to be, something that is more protective from an IP standpoint because they're not training on the data, they're retaining it in much more secure, separate cloud environments. So it's sectioned off from the general public. And, they're using that as the major way to implement the base technology. Now, what's sort of emerged is that it's interesting, it can be useful, but when it comes to more niche use cases, especially in life sciences, they fall short. And because of that, people have begun adopting much more specialist models for particular use cases. And that also kind of leads into something that we'll talk about a little bit later is security considerations and things like that around these models. And if you're working with a company that's providing these, how do you evaluate it? How do you think about bringing it internal and having it be robust enough where you're confident that your personal IP or company's IP isn't going to leak? So I think that kind of articulates the way that these language models are being used for efficiency purposes within the companies. Now, on the startup side of things, it's usually a bit more lax. Startups usually tend to be a little bit more technology forward and more willing to allow their employees to utilize those solutions. So, by and large, most of the policies that I've seen, and one that we adopt at our company BioPhy, is we actually encourage the use of them outside of basically domains which we would consider sensitive or are a competitive advantage. We are an artificial intelligence company ourselves, so we oftentimes will use it to generate copy, to brainstorm, and do all of these other sorts of functions, which normally would take us quite a bit of time, but aren't our specialty, aren't our competitive advantage. So that seems to be the way that most things are being implemented for earlier stage companies. Now, by and large, the intersection of those two kind of goes over to the drug discovery and development side of things. Now, there's two major categories that I would I'd pose there. There's the incumbent pharmaceutical companies who are very traditional and are looking to effectively bring in new technologies and accelerate their path to using artificial intelligence to discover these new drugs. To be honest with you, that part of the industry seems like a bit of fear of missing out or FOMO right now because there's the general feeling of, I guess you could say, anxiety from these companies that if they don't play the game, they're going to be behind when one of these things hits or some technique is validated as being useful in this capacity. And if they're not in the game, they will be behind. So there's a lot of focus on how do we bring in the right partners, the right assets in order to do that. Though there's a lot of deals that have gone through in that space recently. Probably the biggest and splashiest would be Isomorphic Labs, which is DeepMind's biotech that's specifically using machine learning for drug development, partnering with Eli Lilly and Novartis for a deal that's worth upwards of a few $billions. Now, on the other side of things, there's I guess what you could call like incumbent artificial intelligence first drug development companies. A good example here is a Recursion Pharmaceuticals. So they were built from the ground up to be artificial intelligence first in terms of how they approach the process of drug development. And even they're looking at trying to bolster their own technology stack and shore up the weaknesses that they have. As an example, with the acquisition of two smaller companies called Cyclica and Valence. Those were smaller acquisitions. Those were on the order of $40 to $50 million a piece. They weren't huge billion-dollar deals, but they're looking to increase their IP around the space, become more effective, and try to make sure they aren't missing out on the latest technologies as well. So by and large, those are the way that I break down the trends, kind of separating them out into the fundamental driver of what operates the industry, and then the efficiency side of things with the language models.
All right, thank you, Dave, for your insights into the industry. So moving forward now, we're going to talk about some of the maybe legal considerations and best practices, and then I guess from a legal perspective and from a business perspective, probably rely on Dave a little bit more for the business perspective. So to start with, I think one of the biggest problems everyone should be aware of is patent eligibility. We discussed this a little bit earlier. And so patent eligibility, 35 USC 101, that lays out what's eligible to be patented. And there's a lot that goes along with that. Unfortunately, it's not super clear cut what is and what isn't patent eligible. There is a string of cases from the early, I want to say 2010s, can't remember the exact years, that kind of muddied the waters. During patent prosecution, there's the MPEP, that's what the examiners are supposed to follow. But recently, the USPTO has released these guidelines that help examiners follow the MPEP. Based on my experience when I was doing patent prosecution, it's not necessarily compatible in all aspects. But with that said, I think there is decent guidance to help you move it along through prosecution, but whether or not that accurately reflects the current law and how it will be interpreted moving forward, I think is a little bit up in the air. But to go into more detail on this issue, I will introduce Sean, who will elaborate.
Thanks, Jake. Yeah, like Jake said, so there was some cases decided by the Supreme Court that really created some confusion and some issues with respect to 101, even without considering AI. It's been an issue, I think, particularly in software computer architecture, but also in life sciences with respect to drug discovery and particularly with respect to diagnostics and therapeutics and how natural relationships play into what you're trying to claim in a diagnostic. So with that being said, there's the PTO has tried to clarify somewhat. There was a interim guidance in 2019 or an updated guidance in 2019. It did provide a little more structure around what is considered an abstract idea. Prior to that, I think we saw abstract idea as a 101 rejection way too often. Now it needs to fit into one of the enumerated categories. Those include an organization of human activity as one and mathematical processes as another. And those two are really kind of where AI gets wrapped up into abstract ideas and patent eligibility. As with a lot of things patent law related, depending on the examiner you get, it can be subjective and inconsistent the way they apply this. Hopefully as things move forward, there will be some more clarity in terms of abstract idea, how that plays into AI. But that being said, for now, one of the best ways to approach this is to think of it as more of a computer-based invention. go along with the guidelines and the examples they've provided on that front. And some of the most common ways to do this include looking at, does the invention improve the functionality of computer or hardware? And can it be practically performed in the human mind? So from these two questions, one of the things you want to look at and try to highlight as you're going through an invention disclosure or drafting an application is what technical advantages are there from either the training or the execution of the AI, and how can you highlight those to try and show that it improves the functionality of the computer or hardware, or that it cannot be practically performed in the human mind. That being said, if you really can't do that, or just to bolster your arguments, another way to try and avoid the 101 issue is to get into tying it to a practical application, like Jake said. So that includes being more detailed in what space are you in? What's this algorithm or machine learning or AI implementation doing? A lot of times we want to go broad with claims. In this case, it doesn't hurt, I think, to include examples of specific uses and implementations in your application. And then if there is really a main focus, include that in your claims. From there, go into details regarding your training steps, your data specificity, and the precise mechanism of how AI is operating. So that includes, what kind of model is it? Is it a neural network? Are you talking about deep learning, reinforced learning? How are you processing the data? Is there pre-processing? What type of training? Is it guided, unguided training? Things along those lines. All those details help to get you out of the abstract idea realm and into a more concrete, definite series of steps that cannot be performed in the human mind, and likely won't be considered an abstract idea. And then again, also tying that to a practical application can help you to avoid 101. Let's see. And then generally you want to avoid generic recitation of AI, as well as application of existing models to existing data. So similar to kind of any patent application or any set of patent claims, you want to focus on the novel elements, what's new, what was done by the human, what did a human inventor contribute here, and really pull out those details to try and separate it from abstract idea.
Thanks, Sean. I am going to put you on the spot a little bit here because I think one of the questions that was asked kind of ties in nicely to this. So one aspect of patent eligibility is that there hasn't been a public disclosure in the past because we don't want to take things out of the public domain. And so I guess, when would putting something into ChatGPT count as a public disclosure?
So I was actually talking about this the other day with someone, excuse me. And as far as I'm aware, there's no clear guidance on this. I think it's really going to depend on what type of license and where your data is going and where it is. If you have a license that gives you private access or maintains your data in privacy, likely not a public disclosure. On the law firm side, you have to consider, though, if you have multiple clients working on similar technologies, obviously without a conflict, if you're putting info into ChatGPT, even on a private license, you could have cross-contamination, I would think, between one invention disclosure and another. And, it's a real risk, in my opinion. How that plays out and whether that becomes an issue, I'm not sure. But if I were to just take a guess, I would think that if you're going into a public model, you're inputting information and it's there for the algorithm to draw on in deciding other people's, implementing other models. I would say that, yeah, technically that could be considered a public disclosure.
All right, thanks, Sean. So the lawyerly answer, it can depend. All right, so moving forward, I guess from the business perspective, if we are to use AI as a tool, this one's directed towards Dave. What do you think should be done prior to using the AI in research, if anything at all?
Yeah, so I think there's a few major considerations. This is a process I've gone through at Johnson and Johnson, and I've carried forward with me into the work that we do at BioPhy. So the first being doing a thorough audit of the models themselves. It's really important to understand how the infrastructure is built, what security is in place, how the models were trained, and understanding any underlying biases that might change the way that your outputs shape your decision making. If you're not fully informed as to what you're working with as a tool, then it can pose a lot of risk because you may end up making decisions based on biased data and making basically pushing your company in a company or research in a subpar direction. Along with that, from the privacy and cybersecurity standpoint, one of the really important things is basically having third-party verification. This often comes in the form of cybersecurity and data security certification. So if you're looking at these things, look for certifications with standards like ISO 27001, SOC 2 compliance, and things under that umbrella. What that will do is at least give you a baseline of assurances that one, your data is being stored, encrypted, and managed in a way that is robust enough for your research process, and two, it'll just ensure that you have that peace of mind while you're actually utilizing the tool. The last piece that I would touch on would be really having a formal agreement in place with the provider of the artificial intelligence tool to understand what role it's going to play in the research and come to agreements ahead of time around how that role has downstream effects on ownership of whatever is generated by the tools. I think you've heard that echoed a few times here, but that's also sort of fundamental to how those tools are integrated into the process as a whole. So I think that those are probably the most important considerations. And if you do those, I think that you'll be in a very good spot for utilizing those within the process.
Okay, thank you, Dave. And it's your turn to be put on the spot. I saw another question that I think is kind of relates to this. In your experience, so prior to doing AI and research, do you think in the future I'm guessing you have the most experience with this. In the future, do you think there's any possible new regulations for the AI itself with regard to maybe the FDA or anything? Probably specifically related to auditing.
When you say auditing in this particular case, do you mean
like unbiased data and whatnot?
So I think so. The way that I've seen this process evolve over time within larger pharmaceutical companies is the tools are usually developed initially as a supplement or guide to a process. So if you're doing design of a process or a molecule or something like that, it'll usually start out as a way to more quickly find your way to the answer that you're still validating with traditional methods accepted by the FDA. The way that it evolves from there is, maybe becoming a little bit more formal part of the process, but still, validated with the traditional methods. And then kind of the end state is where you're fully relying on the artificial intelligence models as justification or, proof for whatever aspect of development that the FDA is looking at. So I think that as you walk up that technology spectrum and the level of integration of AI into the process, it's inevitable that it becomes sort of an auditable piece of the process. But because it's sort of early days for a lot of these, and they're sort of just being used as guideposts. It's not fully there yet. The other really important thing to remember there is to try to educate the regulatory bodies as to what you're doing ahead of time, and oftentimes educate them as you go and work hand in hand to get their feedback, so that there's no surprise when you get to the end, submit the document, and they're blindsided by some technology and analysis that they've never seen before, and then they need to basically push it all the way back to step one. So that's highly recommended in any of these processes, because you'll get the buy-in along the way, and by the time you get to the end state, everybody will be on the same page, and you'll be in a much better position to be able to actually utilize the technology in a positive way.
Great, thank you. And I think that kind of leads well into the next point that Alex is going to talk about. So it's very clear that AI is getting more and more and more integrated into the research process. And it's clear that AI can bring up, at least it's expected to bring up, some complications with maybe inventorship. So I'll turn to Alex to see what his advice is on ways we can work with that, I guess.
Yeah, and I'll start by saying, that this is still early. Everything's, none of this has really been tested. And frankly, I don't want to be the first person in litigation of a patent to hear an inventor say, I don't know who came up with that. That's what the AI told us to do. But that statement's coming. It's not going to be a good time for whoever has to deal with it. But I do think there's some stuff we can do to help address that potential scenario. So in situations where you're wanting to use AI tools in R&D, if your organization's invention submission workflow can accommodate it, I think using defined checkpoints or a staged approach in your development can be very beneficial. So what I mean by that is you do an initial phase where it's more like a conventional approach, and you specifically do not use any AI tools. So you fill out an invention disclosure, you put down everything you've got at that point. This draws a really clear line in the sand about what you had and who contributed to it prior to any AI use. After that initial phase, you move into what I kind of call an AI planning phase, where those same inventors contemplate how those ideas could be expanded or optimized using AI, again, before they're using the AI tools. So this allows you to document what you intend to do, what you expect to see come out of it. And that analysis is probably the most time-consuming and important part, but it can help you avoid future mischaracterizations of inventorship. And then finally, you implement an AI-assisted phase where you carry out your planning phase. And at the end of each of these phases, you want to make sure you identify any changes to your contribution or your perceived inventorship. So if you have additional people come on board at the planning phase, or additional people come on board with the AI execution phase, you have their roles and contributions very clearly delineated. Who had that idea at the initial phase, who defined those next steps, all that stuff could potentially be very important. Another big caveat here is if during your AI execution phase, something you didn't expect happens, you do at least have a better idea of the subject matter associated with potential inventorship concerns for the future. This is a great opportunity to consider trade secret protection instead of patent filing. If the AI came up with something that you didn't think would happen or way outside the realm of what you expected and it works, I would be very cautious about that and be very calculated about how you protect it. But again, nobody's got a crystal ball. I don't want to be the one dealing with those issues, and anything you can do to head it off, I think the better off you'll be.
Great, thanks, Alex. And so he kind of touched on a point at the end there that I'm gonna move over to Sean, but we have been a little bit patent focused here for intellectual property protection. And so I'm gonna leave it up to Sean to remind us of the other ways that we can maybe protect these ideas.
Sure. So two most common ways, copyright and trade secret. On the software side, copyright is something that can be used. Of course, it requires disclosing a major portion of your code. So, debatable how valuable that ultimately is. On the trade secret side, though, you're talking about essentially, as trade secret implies, a secret of the trade, keeping something in-house, keeping it confidential, and doing it in a way that others can't replicate it easily. One of the benefits of trade secret is that there is no time limit. A patent is 20 years from date of filing. On the trade secret side, you could keep something trade secret indefinitely. So, think of Coca-Cola or Twinkies. Those are trade secrets, obviously both food related, but that have been kept for a long time. And had they been disclosed in a patent, those patents would have expired by now, and it would be public knowledge. That being said, what are the elements necessary to qualify as a trade secret? So the information has to be commercially valuable, has to be known only to a limited group of people, and has to be subject to reasonable steps have to be taken to safeguard the privacy of that information. And that's really where I think the difficulty comes with respect to maintaining trade secrets. That and the fact that if someone reverse engineers your product or independently develops your product, that's not trade secret infringement. It's a viable defense. So, how do you keep it private? Confidentiality agreements, education of employees, making sure that all of your documents are marked confidential. Also, systematic monitoring, keeping track of who's accessing these documents, what are they doing with them, and then when it comes to potential employee departures, especially if it's on bad terms, are they accessing things right before they leave? Do you require that they return and or destroy any trade secret information that they have in their possession? All of these things require active monitoring to maintain the secrecy or propriety of that information. Trade secrets can be used, you can license them. So, it's truly intellectual property, even though it's not, you don't have a registration with a number that you can point to. You can use these as leverage in negotiations, and you can monetize trade secrets as well.
All right, thanks for that insight, Sean. So I think that's all we have for what we had planned, and we're going to open it up to questions now, and I'm going to turn it over to Brian for that.
Thanks, Jacob. For some reason, my camera is not turning on, so I will just speak right here. So we do have a couple questions from the audience. So Michael asked the questions about when AI or machine learning is a predominant part of the drug development process, do you see it being reviewed and regulated like other processes, such as cell culturing, biologic manufacturing in an FDA, NDA application?
I can touch on that briefly just because this is along the lines of what I mentioned earlier. When I was at Johnson & Johnson, we went through that exact kind of tiering process that I mentioned, where initially we developed technology that was which was geared towards increasing the yield of a particular manufacturing process. We also did modeling for lyophilization, which allowed for improving the drying cycles, for example. So in the case of the lyophilization, we really only have found the need to do that first step that I mentioned, where we used it as a guiding tool because it's sort of like a one-off batch process. What we would do is utilize the model to figure out the most efficient thing and then run it, do like a validation run to show that it did what we thought it was going to do. And we never really needed to do any sort of validation because there was nothing in the loop. It was just a guiding tool to figure out what needed to be done more efficiently, and we did it. When it came to the yield increases for manufacturing, it really, in order to accomplish that, the artificial intelligence has to be pretty tightly integrated into the process. And as soon as you're that close to the product, and downstream that's going to ultimately enter the patient, there's a lot more scrutiny around it. So we initially started at looking at how can we change the processes in an offline capacity just by figuring out a better way to operate them. And then eventually we stepped up towards achieving those goals in real time. And as soon as they got that much more involved, it became sort of a part of the filing for the processes rather than just being an informative tool outside. So that was the long-winded answer. The short answer is yes, as soon as it becomes tightly integrated into the process itself, where it is part of the process as opposed to just being a guiding tool outside of it.
What about for Alex and Sean? What do you see from the lawyer's perspective?
Alex, do you have any thoughts on policy side?
I just generally, I think we're going to see more regulation. Just overall, I think as it becomes more ubiquitous and all these other, Microsoft's got a Copilot button on the keyboard coming. I mean, this is going to be in everybody's everyday life in some form, generative AI in the future, and I think it's inevitable that it's going to change a lot of different industries. I mean, I can't speak to the specific question, drug development processes, but I know the government loves to regulate where they can. And I think as case law and, copyright concerns and privacy concerns, personal identifying information, how models are trained, the amount of transparency behind it and ethical considerations, all these factors, I think it's inevitable for whatever that's worth.
Great, thank you, Alex. We have a question here from Mitch on whether AI can be listed as an inventor. So it reminds him of the Citizens United case that says corporations are persons. Is this kind of similar to what's happening with AI? And do you have any insights on that?
I'll take that one if nobody else wants to. I think that it cannot be, as we talked about earlier, cannot be listed as an inventor. The analysis about whether the AI has rights, I don't think we're quite ripe for. Ask me again in 20 years, but yeah, as of right now, I think it's distinguishable from that type of analysis based on, a motivation to protect an entity that isn't an entity yet.
Okay, thank you. Another question here. So when distinguishing between conventional platforms and the latest AI integrated systems for development, so what sets them apart? And for example, what counts as AI and not just conventional prediction model?
I think there's probably a number of ways that you can try to set the two apart. The broadest way to kind of look at that is, what was the input? Did you input traditional programming and your output is molecules? Is it really just a program that you've put together, or is your input data and a problem and the output is a program? Are you training the computer to develop a program to output your molecules, or are you just programming the computer directly to predict? That's one way I can think of. I'm sure there are other ways that you can try to distinguish between the two, though.
I mean, I guess one thing that would be helpful to understand behind that question is what's the motivation? Is it because you're looking to understand if there's value with a new technique or in contrast to what you deem more conventional, or is it something else? I'm going to give the nerd answer here because that's what I am at heart. They're the same thing to me. If you really look at the definitions of artificial intelligence, machine learning, prediction, all of these things, they're sort of nested concepts. And even if you're talking about generative AI, it's still predictive. The way that you generate the molecule coordinates and the bonds is because they're predicting over some distribution what should go there. So although it looks like a shiny new veneer with different terminology and everything, at the end of the day, it's all just math and statistics nested underneath some computer programs. So you want to get technical, I think they're the same things. If you're an investor and you're looking to differentiate, you're probably better off looking at the data sets that underlie the models and see what differentiates there. Or if there's some completely novel sort of algorithm, what sets that apart from some of the other standards. But I don't think you necessarily need to differentiate between predictive technology and artificial intelligence itself.
One really quick thing there that I like to do in similar circumstances is I ask to have it described to me without AI buzzwords. And if that becomes a challenge, then kind of points you in a certain direction.
All right, thank you for this. So we have a few minutes left here. I wanted to kind of ask this for all of the speakers here. So in this ever-changing landscape of AI, what are some expected roadblocks that you can see or predicting that's going to be coming in the next couple of years? Jacob, do you have any perspective from the university side?
I think the biggest challenge at universities right now would be just making just ownership issues in general. A lot of the professors are using things like that they purchase. So especially professors that are outside of maybe the computer sciences and stuff, for example, people in the College of Business, or I'm not saying they're not sophisticated in computer science or anything, but, and I know this is kind of outside the scope of biotech, but for people who aren't really sophisticated in developing a large language model themselves because they can't, or if it's not something that's already owned by the university, just making sure that they know what they're owning when they're using these large language models, because at the end of the day, if the university doesn't own it, then it's hard to do things with it. And if we don't own it, it's kind of a may or may not be a PR nightmare.
Thanks, Jacob. What about you, Alex? Do you have any insights on what are some expected roadblocks?
I think it's going to completely change my industry. I think the legal services are going to shift even further in a direction of automation, and I don't necessarily see that as a bad thing. But I think both from a lawyer's perspective and maybe an engineer's perspective or an inventor's perspective, a big risk is the people who understand how to use this tech are gonna leave, and might leave. It might be too much reliance on somebody without proper documentation of what they've done, and maybe it's not even something that individual owns, but they take the knowledge of how to use it with them, and you have this huge vacuum remaining. So I think, again, it's very important to document what you can and have multiple people involved when you're working with this type of technology.
What about Sean or Dave? Do you have anything to add?
Yeah, just on the patent protection side, as with any technology in any space, the more crowded it gets, the more difficult it is to push inventions through. And that obviousness determination is going to become more and more difficult the more art there is. So just remembering you need details about how you're accomplishing these things, and really going into specifics as opposed to just applying AI. It's going to be more difficult going forward for sure.
I guess just closing thoughts in terms of roadblocks. I guess I tend to think about this at a little bit higher of a level, and where artificial intelligence is, where it's come in a very rapid period of time over the past 1 to 3 years. Not to say that there hasn't been massive progress in the past, but there's been a large inflection point because of some of the developments in compute power that are available today. Now, if you keep tabs on the rate at which this is progressing, I think the rate of progress is accelerating very, very quickly. What I would expect is the roadblocks are actually going to be in the form of, I guess you could say, like some more fundamental occurrences that change the way that people think about whether you should or shouldn't use these tools and how you should use them. An example of what I mean is, in terms of like self-driving cars, as an example, when you've got a Waymo car that has no driver and ends up hitting a pedestrian, who's at fault? Is it the programmer? Is it the pedestrian? Is it the company? And although if you look statistically that technically those cars probably have lower incidence rates than actual drivers, it just highlights to the public in a very sensationalized way that there's still risks associated with these things, and there's a lot of use cases that are going to emerge like that with much more advanced models that will be coming in the near future that we're not even thinking about. And I think those are going to end up causing a lot of these roadblocks that we don't even see, because they're going to get very large scale attention. They're going to motivate significant regulation, and that's going to really change the landscape in the way that we're potentially even allowed to use them. So that's the way I personally think about it, but I'm very optimistic in general. So
Awesome. Thank you, Dave. And that was very interesting and a great example of the self-driving cars. So I want to take this time to thank the speakers. Thank you, Jacob, for moderating the panel. Alex, Sean, Dave, this has been a very insightful conversation. If you guys have any questions, feel free, or if the audience has any more questions, feel free to reach out, or feel free to reach out to the panelists. You saw their emails there. And that's it. Thank you, everybody, for watching, and have a great weekend.
thank you, everyone. Have a nice day.
Thank you.